Welcome back. Now, the South African Human Rights Commission, the SAHRC's bite, has been muzzled by the Supreme Court. This after the Commission issued directives to a farm employer in Mpumalanga. Workers complained that their right to access water was violated, but the High Court and the SCA ruled that the SAHRC, the Human Rights Commission, does not have the authority to issue binding directives. And now this becomes an argument and a discussion about who is authorized to do what. Well, thankfully for me, I have Cliff Decker, Hofmeyer's associate in dispute resolution, Tanya Calitz, who's been very kind so early on a Saturday morning, 7:15. Tanya, morning, and you've made time for us to try and unpack this. I also would have been under the impression that the Human Rights Commission, just by their very title, would have a bit more bite, but it seems that the High Court and SCA don't quite agree. Just help me understand, what's your takeaway from this story? Good morning, Tanya.
Good morning, Gareth, and good morning to the listeners. It's wonderful to be here with you. So the High Court and the Supreme Court of Appeal basically did an interpretation exercise where they looked at the Constitution, Section 184, the powers and function of the Commission, and they also looked at the Commission's Act. And they did an interpretation exercise and they took a textual approach to see, but how far does the powers of the Commission extend to? And they came to the conclusion that the Commission does not have the powers to make binding directives. And that's what both these courts decided. So that's currently the position in law until the Constitutional Court sets it aside. And we are also aware that the Commission did approach the Constitutional Court to have that set aside.
Because this can become a very, very complicated issue. And as someone who deals in dispute resolution for a living, Tanya, I know that it can get very muddy in the waters as well. So what I understand here then, this interpretation exercise had taken place. They've come out, both the SCA and the High Court, and said the Human Rights Commission really has no power. Does this essentially disempower the Human Rights Commission from anything that they say in public, anything they say in the media? Essentially, it becomes just nothing more than an opinion. Is that what I'm understanding here?
Gareth, I think we must keep in mind that the Commission still has many other powers and functions. They can still investigate, they can still mediate, they can still educate on human rights. So we shouldn't take away from the other functions that they have, which doesn't render them completely obsolete. But I think in this instance specifically, the fact that they cannot issue directives that are binding, that has power in the effect that it's binding, it does make them a bit less powerful, if I can put it like that. But I don't think, it doesn't take away from the core function which they were created for, to strengthen constitutional democracy and then also to protect, monitor and promote human rights. They can still do that without this function.
I'm wondering, because when a decision is made by high courts and the SCA, Supreme Court of Appeal, in a case like this, this might be slightly out of your ambit, Tanya, and forgive me if I'm going a little bit off track here, but I can't help but wonder if, as according to the High Court and the SCA, this interpretation exercise has come to this decision. What does that mean for previous recommendations and binding recommendations made by the SAHRC in previous decisions, in previous cases? Are those null and void, or is that not part of this going forward? I'm not a qualified lawyer, so maybe you need to help me a little bit.
Yes, Gareth, so those remain in force until this judgment, until the date of the judgment takes effect or came into action. Going from that date onwards, this would be the legal position, which is that the Commission does not have the authority to issue binding directives.
Okay, so from this day going forward, I wanted to just clarify that as well. Legally, I wonder as well if you can help me understand, what does the SAHRC does here, or what do they need to do in order to gain that sort of, I don't want to say privilege, but that power to be able to make binding declarations? What do they need to do to satisfy both the High Court and the Supreme Court of Appeal? Is there anything they can do legally to get that kind of binding power?
Yes, so Gareth, they did approach the Constitutional Court last week, and they filed papers there to have the case heard in Constitutional Court so that the Constitutional Court, as the apex court, can make a decision on what their powers extend to and what not. I have had the opportunity to read their papers, which is quite a lengthy application, but it's they really just ask the court to take a wider approach, a contextual approach, and to look closely at Section 184 and at the Commission, the Human Rights Commissions Act, and to read in that they do have these binding powers. So they are still in disagreement with the Supreme Court of Appeal's judgment, and they are really asking the court to look at, to really carefully look at the statute, look at the clauses, and to make a reading in that they have these powers. I think, Gareth, just an important thing to also note is they rely heavily on the EFF Nkandla judgment of 2016, where the Constitutional Court said that the public protector has powers to make, has these remedial powers. And so they lean and rely heavily on that judgment. And you'll also see in their application, there are a lot of snippets taken from that judgment where they are confused as to why does the public protector has these powers but not the commission, and that's the main point of argument in the Constitutional Court. So fortunate for us, we have the Constitutional Court who will interpret this and who will set the law straight and make the right finding.
All right, so that's where it's going to next, and I really appreciate your time in joining us this morning. CDH, Associate in Dispute Resolution, CDH standing for Cliff Decker Hoffmeyer, dispute resolution expert and lawyer. Tanya Calitz joining us this morning. So it's all about Section 184, the Human Rights Commission Act, and now what is the remedial action of the South African Human Rights Council. It's now going all the way up to the Constitutional Court as well. It's interesting, isn't it, that the fact that they're bringing into the discussion the powers, for example, of the public protector. I just wanted to set the scene there with Tanya Calitz, and I appreciate her time so early on a Saturday morning. Eastern Cape